Welcome to the Meet the Experts Revisited. My name is Susan Dabiani, and I'm the Director of Gift Planning, and I'm also the Director of the McAllen Society, which is our legacy society. The reason why I have it titled Meet the Experts Revisited is because probably since I've been here, which next month will be 21 years at St. John's, when I started Meet the Experts, it was about 21 years ago, and I think Professor Clark was my moderator for the last 21 years as well. And we're saying revisited because this is the first time, believe it or not, that we've actually brought it online. I got a lot of great feedback, and everybody said that they would really enjoy, getting to listen to all this great information, because Meet the Experts, we only do once a year, and we do it in person, usually in the Manhasset or Garden City, or where's the last one we had? I guess it's East Williston is where we have it. So hopefully now we can get to everyone across the country. And we have a great panel of experts. So I'm going to introduce them to you right now. We have, as I mentioned, our moderator, Professor John, as we call him, Jack Clark. He's a graduate of St. John's 1955 College of Business Administration and 1957 Law. He was admitted to the practice of law in 1958, and he has been in private practice since that time, specializing in trusts and estates, including extensive experience in estate administration and probate and accounting litigation. And he is also in 1967, believe it or not, he joined the faculty of the Department of Law at St. John's University College of Business Administration, and he continues teaching, and also as the chair of the department in 1997, and then in 2007 he did return again. The school then was called St. John's, and still is called St. John's Peter J. Tobin College of Business. So he is a wealth of knowledge, not only in his expertise, but also as our St. John's expert with our institutional history. So thank you, Jack, once again for moderating this discussion. The next panelist we have is Patricia Canal. Patricia is a graduate of St. John's University, 1985. It was called St. Vincent's College. It's now called the Collins College of Professional Studies, and she also got her MLS in 2011. She specializes in assisting clients with homes being sold as part of inheritance or trust. So thank you, Pat, for joining us. Our next expert is John Separano. We actually went to school together at St. John's. John graduated in 1985 from St. John's University from the College of Business Administration and Finance. And as I always share with you, he was also a cheerleader for St. John's. So we thank you for joining us. John provides investment and wealth management advice to high net worth families and individuals, particularly business owners. He continues to grow their assets with an emphasis on minimizing their taxes. And John has over 25 years of experience in financial planning, taxation, business consultant, and financial counseling. And then our next expert is Phyllis Ann Polizzi Kalenka. She's also a graduate of St. John's, 1987 from St. John's College, 1990 from the School of Law. She began her legal career as an associate in the law offices of Spelman and Walsh in 1990. And throughout her years of practice, she's worked with numerous individuals, families, trusts, financial and not-for-profit institutions. Her practice concentrates in the area of estate planning, estate administration, residential real estate agency, and private placement adoptions and not-for-profit. The next expert we have, I know on your list, you were probably expecting Joseph Bellotti. Unfortunately, he's sick with the flu, and so Patrick's our angel. He came to our rescue. Patrick Kearns is a fourth-generation funeral director and the president of Leo F. Kearns Funeral Home, which has 4 locations serving Queens and Long Island. Now, Patrick is not a St. John's University graduate. His wife is. She's a graduate of the School of Law, Jean, and she's a trust and estate attorney, ironically. But we still, like I said, he came to our rescue. So we can't blame him for graduating from the University of Notre Dame in 1992. And then he studied at the American Academy McAllister Institute in Manhattan, where he received his certificate of funeral service. And he has been a New York State licensed funeral director for over 30 years. And then we have the wonderful Tanya Hobson Williams, and she is our expert in elder law. The host of experience that she brings is unbelievable and invaluable. And I did, even for myself, learn a lot from the last conversation that we had back in September. So thank you, all of you, for joining us. We really appreciate it. I'm going to turn it over to Professor Clark, who will begin our panel discussion. And I hope you came with lots of questions. We want you to walk away with learning something. And if we, this discussion is about an hour. If we do not answer all your questions because time ran off, I ask that you email my office and we can make sure that we get your questions answered by all the experts. And we will also list all their contact information at the end of this discussion. So once again, thank you.
Okay, thank you. As Susan mentioned, we've normally done this in person with a rather formal presentation by each of our panelists and then questions at the end. This format really doesn't work in this virtual setting, so that what I'm going to do is I'm going to direct certain questions at each of the panelists and kind of tighten it up. And then if, depending on the answers and so on, perhaps shift over to another panelist to comment on that. But generally speaking, I'll use the same format of going to each panelist, but with questions rather than an open-ended presentation. And then when we've gone through the initial questions, which, by the way, were formulated pretty much internally, the panelists suggested some and the staff suggested some. So when I use those up, we may just then ask for the chat questions to come in, and we'll feed them accordingly, as we've always done. So thank you very much for participating again. And I'd like to start off with a question to John Ceperano on the wealth management end of the program. John, I know a lot of changes may be in store, but generally speaking, what would you suggest to a soon-to-be retiree in planning to deal with their IRA plans or their 403B plans or whatever, to lessen the tax burden and also allow them to do some charitable contributions while taking care of their beneficiaries at the same time?
Thanks, Jack. That is a loaded question with a lot of questions in it, so I'll try to break it down a little bit. The answer is always going to be, it depends on people's facts and circumstances, and you're going to find that that's the case with every other panelist on here. Everybody can come in with the same amount of money, but to have different ages, different health situations, differences in marriages or not, whether married or not, and they have different time frames on when they want to retire, and that will either enhance or limit their time frame to get things done. So if you have a young retiree, just let's say somebody 60 or less, or even 62 or less, they're not going to be eligible for Social Security just yet. And they may not need to because, some people are concerned that Social Security is going to run out. I think just my own opinion from many years of answering that question is that it would be some form of political nightmare for anybody who took office that would get rid of Social Security. So there's other ways that they're going to find ways to tax us if they need to raise money for whatever programs the government is going to work on. So I think for the next 5 to 10 years, it's not a major issue other than them possibly making some of those changes. But people leave work and they've either accumulated money on their own in taxable accounts, or as Jack said, in retirement accounts, in either IRAs on their own or some form of qualified plan, which just mean that it falls under ERISA. You don't have to know anything about that, but it's either in a 401k plan if you work for a profit company, or a 403b if you work for a non-for-profit like a hospital or some other kind of municipality. The choices inside of those plans may be good, and you may not want to roll them out right away. However, one of the things that a lot of people don't realize is when they're in qualified plans, your money, you also can't do what's known as Roth conversions until they get to a self-directed IRA. Okay, so that is very important to note. You don't necessarily have to do it immediately, but you want to at least look at what your options are as soon as you can. Sometimes 401k plans only have a limited choice of, they don't have a open architecture and you only have 25 to 30 choices of investments. And they may not necessarily be the best for everybody in the individual circumstances. So if you are married with somebody, they also may be working, and you'd want to try to get with an advisor, an investment advisor who understands taxes, so they can coordinate what's best for both of you as an overall plan for your investments and your retirement and the time you need. So charities, in terms of giving money away, the standard deduction has risen so high that it's hard for almost anybody to take deductions if they don't have a mortgage anymore. And real estate taxes have been limited to $10,000 a year. They're looking to make some changes in that law, but until those laws pass, we're stuck with what we have. And assuming you're somewhat healthy, you're not going to get any medical deductions. So the standard deductions for a person that's, let's see here, I wrote this down here. Standard deduction for a single person this year, under 65 is 15,000, over 65 is 17, under 65 for married couple is 30. It's just double everything. So to get over that, it would be really hard. So what people can do if they are charitably inclined is they can set up donor advised funds. And donor advised funds are a way to reduce your estate and reduce your income taxes. Now, most people on the call probably will not have estate tax issues if the laws stand where they are right now. I'll let the estate planning attorneys get involved there, but they are close to 14 million right now in that area per person. So if we're talking about trying to reduce their taxes and do things with their investment, they should get with somebody to see whether or not they should be doing Roth conversions before they are required to take out required minimum distributions out of these retirement plans. And depending on your age and when you were born, it is, assuming we're talking about younger people, it's either going to be 73 years old or 75. And I think I'm in the latter group, thank God, I'm still young. And I think the cutoff point was somewhere around like 1961 or 62. I'd have to look it up, but it'll depend. And during those years, you'll have time to make the decisions with a person who understands taxes, with your tax planner and or investment person who understands tax. I happen to be lucky and blessed that I started out as a CPA and then morphed into the finance side to help people out. So I have that background, so it's easy for me having conversations. But one thing I want to leave you on now, and I'll let the next panelist go, is that the consideration for taking money out of IRAs early and putting them into Roths has a number of positive potential effects for you. When you start taking money out and you have a sizable amount of retirement income, you're going to pay more once you get to 65 in Medicare premiums. And those Medicare premiums will continue to potentially grow. They grow with inflation, but sometimes if your income is growing faster and the RMDs start coming out, you may be stuck in a really high tax bracket. So doing Roth conversions is something that should be considered. And I will go over later on when we have further discussions about how that money can build up over a lifetime, up to some people paying about an extra $50,000 to $60,000, depending on how long they live in Medicare premiums. That may be unnecessary if they do it sooner than later.
John, let me ask you, if if I have beneficiaries, people that I want to take care of under my will or as beneficiaries of my plan, how can I adjust them with charitable giving? Can I give a portion to one or the other?
Well, the best gift that you can give to an heir is a Roth IRA because they will pay no taxes and they have to take it out other than your own spouse within a 10-year period. It's a law that came out about like 5 or 6 years ago. If they are a son or a daughter or a friend or an aunt, an uncle, sister, brother, they also have to take it out within a short period of time, 10 years. So if you're going to give money away to charities, you want it coming out of an IRA because the charities will get it tax-free and you won't pay any taxes on it. As a matter of fact, you will get potentially a deduction depending on the size that you give away. So that is part of planning and deciding how you want to either bunch them together, put it in a donor advised fund, give out one large sum. Everybody's in different positions with the sources of money that they need to run their lives and enjoy, spending well, as I call it. So they don't want to give away things. And I find out that what I found out generationally, people 65 or older who live with depression mentality, parents, I did, okay, or ones that followed that same suit, may be very hesitant to give away contributions during their lifetime because they're afraid they may run out of money or have to ask their children for money or somebody else. That is the big hesitancy. And I think that comes down to nobody exposing them to see how things could work out if they plan accordingly now and decide what they can afford now versus later.
Thank you. Pat, if I may, on a real estate issue, a lot of people eyeing retirement or moving on in the years, thinking about downsizing in real estate. What general advice do you give people coming to you about downsizing?
You're on mute, Pat.
Gotcha. Hello, everyone. So, my advice would be always, if you are even considering downsizing, whether you're thinking about doing it now, 6 months from now, 6 years from now, the reality is getting yourself a plan of action in advance is always the best course of action. So partnering with a trusted realtor that you can sit down and have a conversation with, talk through some of your goals. Your realtor should be your strategic partner. And in that conversation, I see it often, are things that come up which have to do with trusts and estates or elder care or tax accountancy. A trusted realtor, because they deal with all of these issues peripherally, of course, should be able to even advise you or give you some recommendations as to who to speak with as you're talking through your plan with your real estate needs, because real estate needs can become very complex. There's a lot of pieces to it, and we don't work in a silo. Most of us don't. Working together in partnership is really the key, but getting ahead of it, because oftentimes people wait until they're in an urgent situation, and it changes how you operate when you're in an urgent situation. So even if I have clients that I'm working with for years that are not yet ready, but periodically we go through their estate, we talk about the valuation of their property, what they could do to keep their property stable and sound, so that when it comes time to sell, they'll get the most money for the property. So that's really getting ahead of it. Planning in advance, if you can, is really the best thing.
Thank you. I'm sure we'll have questions from our audience on that as well.
My pleasure.
So now to get a little more somber, but we have to think about it. Think about our plans for funeral and when we pass on. So Patrick, what would you advise pre-planning? What are the key things that would be helpful to those of us who are optimistic but practical as well.
Sure. Thank you. It's a good question. I think most importantly is starting that conversation with your family, having a conversation about what your wishes are, and making those known. And then, doing a little research with your local funeral director. You can meet with them. They can go over with you the logistics of the funeral, the price and costs of the funeral. And then New York State has a fantastic pre-plan program. New York State has probably the gold standard in the country in requiring 100% trust. New York State doesn't have any insurance products. There are some states that have products where the insurance beneficiary is a funeral home and you purchase a policy that should cover your funeral. New York State prefers and is a fantastic 100% trust law. So 100% of the money that you would have put into a prepaid funeral will go into an interest-bearing FDIC insured account. Currently, New York State has about $840 million in their pre-plan. So each family member for their own pre-plan earns about almost 3% interest right now on the program. And that varies obviously with the current rates, but currently now it's about 3%, which is probably better than you'll get anywhere else for your money. It's also, New York State also has portability with the program. So a prearranged funeral, prepaid funeral in New York State is 100% portable, which means that you can prearrange with one funeral home, and then if your situation were to change for any reason, you can use that prearranged, pre-planned trust with any funeral home in the country. So it doesn't even have to be in New York. If you were to set up your trust fund here in New York and then move to Florida, a funeral director in Florida could submit the paperwork to get paid from the trust in Florida. Or it might just be locally, your local funeral home might change ownership or might go out of business. Again, you can take your pre-planned trust to any funeral home and they could submit the paperwork to get paid for the funeral at the time. So it's a really, New York State is truly a gold standard for prearranged funerals.
And how about designating someone to make decisions about your funeral and et cetera?
Yes, very good. Probably one of the most underutilized tools that the state has is a number of years ago, they created the designated agent, which is it's Health Law 4201, I believe. And that allows a family member or an individual to designate someone to be their funeral agent. And that funeral agent actually supersedes anyone else in the decision-making of the funeral. So combined with a prearranged funeral and then appointing an agent, you really guarantee that your wishes will be honored. And so there's different reasons why that might come into play. It might be your family situation might not be aligned with other family members. Your wishes might not be aligned with their beliefs. We had a number of families from one of the local parishes set up agents for their funerals because they wanted a traditional Catholic funeral, but weren't confident that their children would honor those wishes because their children were no longer practicing. So they would set up an agent just to assure that they got the funeral that they wished to have. It's also very helpful for cremation. If you want to be cremated and you don't have a living relative, there's really no one to authorize your cremation. New York State requires next of kin authorization for a cremation. So if you don't have a next of kin, if you don't have a living relative, you can appoint an agent, and that agent is able to authorize your cremation. So for cremation, it's a very useful tool for folks that just you may not have any close relatives, anyone in the state to authorize that cremation. And putting it, a lot of people will think, well, if I put it in my will, it's actually, your will is not a good place to put your funeral wishes. Often your funeral happens long before your will is ever going to be looked at or probated or anything. So a lot of folks think that, well, if I put my wishes in my will, they're covered. And that is not a good place to put your funeral wishes. You really should make pre-arrangements if you want specific wishes to be honored. And that 4201 agent designation is a really helpful tool. We advise a lot of families, even if they have relatives, to still designate an agent for their funeral.
Would the 4201 agent supersede the wishes of the executive?
Yes.
Thank you. Okay, so now let's move on. Again, we'll get into some pessimism thinking going forward. Somebody comes in, I know I've gotten this question for years and years, ever before New York had a revocable living trust or anything else. They'd go to Florida for a month or sometimes even less and come back and say, I need a trust. Why do you need a trust? And you get a number of reasons. So I want to concentrate for Tanya on, I want to, in case I end up in a nursing home, I want to defeat Medicaid. Where I don't want my money to go to the nursing home. So how would I handle that particular trust?
Okay, so in New York State, right, which is where I'm licensed, so the rules may be different in other states, so you need to keep that in mind. So if you are a resident of New York State and you're looking to qualify for Medicaid, and you have assets, right, that you want to protect, we recommend an irrevocable Medicaid asset protection trust. So the trust that's created has to be irrevocable. It cannot be what's called a living trust or a revocable trust, because a revocable trust, you are permitted to withdraw money at your leisure, right? And so if you are looking for assistance to pay for long-term care and you have a revocable trust and you have funds in it, the state or the local agency will say, well, you have this irrevocable trust with money in it, go in, pull it out, and pay for your care. We're not going to help you. You have this trust here that has funds in it. So the trust must be irrevocable. It must be created so that the principal assets in the trust are not able to be withdrawn. So with a Medicaid Asset Protection Trust, you're entitled to the income or the interest generated from the trust. So if it's real estate and you have rental income, you're entitled to the rental income to the extent that it's not needed to maintain the property, or if it's invested in some asset and you're generating income or interest from it, you're entitled to that. But at no time can you say, well, I want to go to Florida and I need airfare, so let me take out $5,000 from my irrevocable trust to do that. So if you do that, I mean, there's really, unless the bank prohibits you from doing so, if you are physically able to withdraw funds from that irrevocable trust, then it's called a sham trust, okay? And Medicaid will not honor it. So they will look at the bank statements and look at any deposits or withdrawals to determine whether or not you've withdrawn any monies from that irrevocable trust. Now, if you have real estate in that irrevocable trust and you want to sell it, you can do that. The trustee typically has the authority to sell the property that's in the trust. However, If you use the proceeds from that sale and you purchase a new property, typically that new property has to become a trust asset. Or if the proceeds from the sale of the property in the trust, you don't buy a new property and you just take the proceeds, that money that you get from the sale has to go into the trust. Okay? And you need to be mindful when you are setting up this trust that it is not an exempt transfer. So the assets that you place into this trust will be subject to a 5-year look-back period in New York State. Okay, so you have to be mindful of the timing when you do these things and anticipate whether you're going to need these funds that you're putting in the trust for any emergency or repairs or anything of that nature, and know that you're not going to have access to it, and that it will be subject to a 5-year look-back period for nursing home Medicaid. So you have to be mindful that there is a difference between the rules between nursing home Medicaid and home care. Okay, so home care in New York State is not subject to a 5-year look-back period. So if you're transferring your property into a trust, a Medicaid Asset Protection Trust, and you're getting home care, it's not subject to that 5-year look-back period, and you can still qualify.
What generally are the qualifications to get Medicaid? Let's say, aside, I don't have a trust, but I have some money, I have some income. Do I have to pay, or will I be able to get the advantage of Medicaid coverage?
Right. So once again, the rules are different for home care Medicaid and nursing home Medicaid. So you have to determine which Medicaid you're interested in receiving. For both programs, generally speaking, in 2024 and to an extent 2025, Medicaid will not allow you to have resources, which would include bank accounts, stocks, bonds, mutual funds, IRAs, all those things, in excess of, I believe it's $31,175. So if you have money in excess of that amount, then typically you're not eligible to receive Medicaid. Okay, so there are planning techniques that elder law attorneys put in place so that you can qualify without spending your assets down. So for example, if you have $100,000, obviously you have more than the $31,000 Medicaid allows, right? So for many years, people believe, well, I have $100,000, I'm not eligible for Medicaid, so I'm not even going to apply. And there are still some organizations, right, that tell people that you have too much money, you don't qualify for Medicaid. However, there are techniques that can be done so that a person can become eligible without spending the whole $100,000. Because if you do that, then there's no reason to go to John or to Phyllis Ann, right, to plan, because you don't have any money left because you spent it all. So it makes sense to go to an attorney who specializes in this, who can help you preserve those assets so that you can invest them, whether it's in a trust, and you have something to leave to your family, to your heirs. So you want to make sure that you're consulting with someone who can put in planning techniques. Now for home care, right, you can have income for a single person in excess of $1,732. So many people that come to see me, their monthly income exceeds that, right? And so once again, they're told you don't qualify. You have Social Security and pension and all those things together are $5,000. So you exceed the Medicaid limit and you don't qualify. Once again, that is a myth. And you need to speak with someone who can advise you, for example, that you can use a pooled income trust, right, to reduce your monthly income to the Medicaid limit. And any amount that exceeds the Medicaid limit will go to the pooled trust company. So once again, people think, well, if I'm giving my money away to a pooled trust company, I don't have access to it. I don't want to give my monthly income away. I need my monthly income. I have a mortgage, I have taxes, I have insurance that I have to pay. But what the pooled income trust company does is they take the money that you give to them and they pay that bill for you. So if you're giving them $3,000 every month, they're going to take that $3,000. If you have a mortgage of $2,500, they'll pay the mortgage directly, the $2,500, and you have $500 left over. So maybe you have a cable bill of $250. So they'll take $250 and pay your cable bill. Maybe you have insurance for $250. So they'll expend all the money that you give them on the bills that you provide to them every month. Now, the important part about that is whatever you give them every month, you want to make sure that they're paying it out every month, the total amount. Because if the individual passes away and there's a balance with the pooled trust company, the pooled trust company gets to keep it. So if you pass away and they're holding $5,000, they get to keep that $5,000. So the goal is to make sure if you're giving them $5,000 every month, they're spending $5,000 every month. So these are some of the techniques that are used to make people eligible for home care, right? But nursing home care is a little different. With nursing home, you're not able to establish a pooled income trust to qualify. When a person's in a nursing home, their monthly income, most of it goes directly to the nursing home. You're typically only able to keep $50 a month in a personal needs account, and the balance goes to the nursing home. If there's a shortfall and your monthly income doesn't cover the entire nursing home bill, that's when Medicaid could typically kick in and cover the shortfall. So
Okay.
hopefully that answered your
That's
question.
very good. Thank you. Now, I have enough money left and I want to trust, because I want to avoid probate or some other reason. Phyllis Ann, what do you recommend now that people have? Should everyone have a will, etc.?
Even the most basic estate plan should involve not only either a will or a will and a trust, and you can have a trust for any purpose. You can have a revocable or an irrevocable trust. You can have an irrevocable trust for the purpose Tanya just described, or for many other purposes. But you should have either a will, or if you're having a revocable, if you'd like a revocable trust to avoid the process of probate, you still need a will. You also still need to consider executing documents that will help you while you are living, such as a power of attorney, a healthcare proxy, and a living will or statement of intent, as it's commonly referred to in New York. And even the most basic estate plan should encompass those documents. Now, the trend lately that I've been seeing has been that most people are trying to avoid probate for several reasons. One of the reasons happens to be that a lot of the surrogates courts in New York have unfortunately been detrimentally impacted by COVID. They've lost a lot of experienced personnel, and the processing times for probate have become quite significant in comparison to what they used to be. Probate is not a complicated proceeding if no one is going to contest your will. It's essentially accomplished on paperwork. The usual processing time, depending upon the county, prior to COVID, might have been maybe 4 to 6 weeks, possibly 8 weeks or so. Unfortunately, those processing times have become months now, and in some cases, and in complicated estates, even over a year. So a lot of people are using revocable trusts as a means to avoid probate to ensure a smooth transition of assets to family members, particularly individuals who have interest in closely held family businesses. Without probate, those businesses might come to a standstill. So use of a revocable trust can ensure a smooth transition of power, continued operations of that family business. And even in the setting where you don't have a small family business, a revocable trust can allow your spouse or your children to step in to take control of your assets, to address expenses, to address family needs a lot faster than probate might. Okay. Each case will vary depending upon what your personal needs are and where you reside. Probate's generally governed by the county in which you reside in. Some of the courts, their processing times are improving, but they're still behind what they used to be. So revocable trust is a common mechanism to establish ownership of your assets now for control now while you are living, as well as after you've died. And a revocable trust, you are usually the person creating the trust, so you are usually known as the grantor. You are usually also the primary trustee of the trust, so you have full control of the assets owned by the trust, and you're generally always the primary beneficiary of the trust until you die. Now, the trust document itself will then appoint a successor trustee if you become incapacitated or if you pass away, and it will also appoint subsequent beneficiaries when you do pass away. The beauty of a revocable trust is accomplished if you follow a two-step process, and the two-step process involves not only creating the trust, which is the first step in the process, but the second step in the process, which is critical, is transfer of ownership of your assets to the trust. What you have to remember is that a revocable trust will only control those assets that are owned by the trust or which are payable to the trust as a beneficiary. What many people do not realize is that your last will and testament also controls only those assets which you own in your individual name. If you own assets jointly or payable to designated beneficiaries, those beneficiary designations or joint tenancy designations will control that asset despite your will. So when you're creating an estate plan, regardless of whether you're using a revocable trust or you're using a last will and testament, it is critical that you look at your assets and that your advisor, your attorney, involve your financial advisor, your accountant if necessary, your real estate advisor, and that they review how you own your assets, who your beneficiaries are, to determine whether changes are necessary. You could have the best will in the world and it might not control anything. So what you need to do is have an advisor prepare the documents that you need to implement the plan that you want to create. But then you also need your other advisors involved to help make those assets subject to the plan that you've worked hard to implement.
Then you don't need a will, or
Not necessarily, Jack. Okay, so beneficiary designations and joint ownership designations are very helpful. However, they cannot accomplish certain things. A will or a revocable trust can provide for a disabled beneficiary, a minor beneficiary, can also minimize estate taxes because those agreements can incorporate subtrust or testamentary trust to minimize estate taxes as between spouses, and also the beneficiary designations, unfortunately, I've seen them frustrate the provisions that a testator put in place under a will and that a person had created under their revocable trust. So they are helpful, but they need to be coordinated with your entire estate plan. Because if not, as I said, you could create the best documents in the world, but they might not control everything that you own.
if you created a revocable living trust, would you also recommend a will to go with it?
Yes, I do, because for two reasons. First of all, it's a revocable trust. That means you can revoke it at any time. If you revoke it and you do not have a will, then your assets that you own in your individual name will pass according to the laws of intestacy of New York. Those laws prescribe a particular order of priority for your heirs to inherit, and it might not be the same order which you have established under your will. For example, what most people don't realize is that the laws of intestacy say if you die owning assets in your individual name and you do not have a will, and you're married and you have children, part of those assets go to your spouse and part go to your children. They do not, most people, in my experience, in my area of practice, most husbands and wives leave their assets to their spouse first, their children second. Under the laws of intestacy, that is not the case. And under the laws of intestacy, you cannot provide for charities, you cannot provide for friends, you cannot provide for other family members that supersede this order of priority. So the first reason why you need to have a will when you have a revocable trust is in the event you revoke that will. Second reason why you need a will is in the event you never get to complete step 2 of the funding of the trust process. So if you forget about this bank account that you've had that's been sitting, unused for years and it's still registered in your name at the time of your death, if it's not owned by the trust at the time of your death, it's going to pass by intestacy if you do not have a will. Now, the most common type of will that's used when you create a revocable trust is a will that is known as a pour-over will. And it's called a pour-over will because essentially the document says, if I die and I own assets in my name and my revocable trust exists at the time of my death, my executor is to collect those individually owned assets and pour them into my trust for my trust designations to control the disposition of those assets.
Very good, thank you.
Welcome.
Now,
Yeah.
do we have any questions?
Yeah, we're going to turn it over to all of you now who are listening. Thank you, everyone. Thanks the experts for that overview. So far, we only have one question, so please do not be shy. Enter your questions in the chat. We have one question here that says, do you lose step-up basis if an irrevocable trust and go to sell?
Phyllis-Ann, you should.
There is I believe it's a tax court case. Unfortunately, the taxing authorities are attacking basis step up for assets that have been transferred to irrevocable trusts. So there is a question there as to whether that basis step up would be honored, and it does not appear that it would. That seems to be the trend, in that assets transferred to irrevocable trusts will not be eligible for basis step up.
Seen the
Would
same
you
thing
put it
in Florida and North Carolina as well.
Yeah.
It's the same thing because nobody has died, and usually
Right.
that comes upon death. But what will happen is the result of that is whatever the basis was in the hands of the grantor is what the trust gets, and if they sell it in there, that's another thing. And I just want to add a couple of quick comments before we go on to any other questions. One is I just had the situation that Phyllis talked about yesterday in my office. They came in with all their documents. They were ready to sign up and everything. And she's like, we got everything in order. And I said, well, let me see the trust you have. And I go, great. I go, let me see all your statements. Everything was still in individual and joint names. They didn't get to funding the trust. And they go, we know we're reticent about all that. But there's a sense of urgency in doing that because, as I tell everybody, at my age, or you older, or whoever you are walks in my door can walk out my door, fall, hit your head, everything's over that quick. So they think they can always get to these things. Getting to these things, planning them through, not rushing through, but move through the process and know that the next step needs to get done. It's time consuming, but people need to get these things done. So that's why I work a lot with the real estate agents, some things that Patricia talked about, or there may be situations where the kids are my clients, the 50-year-olds or 60-year-olds, but they have the 80-year-old clients, and I got to send them because they don't have enough assets to the Tanyas of the world, or get them to the funeral directors to say, let's not make this a burden on the kids. So my job is a coordinator in many cases. And the biggest problem that most people have is they try to do this all on their own. They go see the attorney, and most attorneys aren't as good as what I hear on this call, I got to tell you, because they'll just answer the questions they're asked. You go to the investment person, they just want to sell you a product. You want to go to the insurance person and try to tell you what you need today, but their life changes and it doesn't ever change afterwards when it does need to. They don't talk about Medicare planning early enough when they start to have health-related issues and they miss these 5-year look-back periods. There's so many things that are so complicated, but getting to have whoever they start with that they get to, the real estate agent, a person like myself, the Medicare person, the fellows, there's a good chance that each of us are going to say, I wonder if you don't have somebody, I need you to get you over here to get these other things done because we have to work in concert together. Because for me, there's a lot of things that are financial, but a lot of things are emotional. And they need time to process. When I get a couple that I've had for a long period of time where somebody refers me a widow or somebody becomes a widow, you don't want to try to make them make major decisions right away, even though financially, yeah, we should jump on this right now. You can't. You got to give them time to digest. So I appreciate that we're able to get together and share these thoughts to our community out there that's listening, that there are so many complicated issues that we have to stay on top of these things ourselves with all these laws that change in every aspect that we have. And you may not think that things change in the funeral area, maybe, but I am sure that Paul can tell you other stories. So I am always learning something from all the other professionals that I work with. I've written down plenty of little tidbits I got to follow up with a number of you on. So it's very interesting how each of us may look like we're standing alone and having these conversations, but we're telling you how, in reality, in everyone's conversation, how we have to interact with each other. And you need to have a really good team, because I got to tell you, the biggest thing I feel like we give all of our clients here, whether it's said or not, is peace of mind that things are in place when they are.
Yes.
Right.
One of the things I'd also like to add is sometimes people are penny wise, pound foolish, right? So they're not interested in paying a professional to provide the services. And there are a lot of online tools that people are using, right, in place of hiring a professional. I've been doing what I do for almost 29 years, and I do a lot of litigation on a lot of these issues. So, for example, speaking about not funding a trust, I had a situation where an individual went online and purchased a trust. And the trust looked pretty good. It said that, when they pass away, they wanted whatever they had first to go to the wife, like Phyllis Ann said, most people do. And if the wife wasn't around, then to the children. And what the asset was a home. The house was never transferred into the trust. So the person died, the spouse died, the children were remaining, but before the last spouse died, he remarried, right? And like Phyllis Ann said, right, that second spouse was entitled to I think it's the first $50,000 and half of the balance.
Yes.
Where the individual wanted his children to inherit, but that didn't happen because he never transferred the house into the trust. So it's very important. I really don't recommend that people go online and pull these documents out of the cloud. For number one, they're not necessarily specific to the state where you reside. And number two, a lot of the organizations that provide that service, they don't direct you on the necessary steps that you need to take to make things valid. So for example, if you pull down a power of attorney for New York State, it may not say that you need 2 witnesses in order for it to be valid. I saw one yesterday. It only had 1 witness. One witness. So it can be challenged as not being valid. So it's very important that you consult with professionals who are specific and knowledgeable in that particular area. So you wouldn't go to a podiatrist, right, if you had a heart problem, right? So you want to make sure that you target your need to the professional who can address your needs.
Right.
Yes.
No, thank you, Tanya. No, and I think that's really the core of why when I first started doing this, all my other colleagues at other organizations were having these estate planning seminars, and no offense to the attorneys, just with the attorney. And number one, sorry, it was boring. And number two, it just, I just
Their
felt
own
like
personalities, Susan.
I know, but I was missing something, and that's why I bring everyone together to stress, like what John was saying and Tanya, that it's really like a team approach. And like Tanya said, you wouldn't go to a foot doctor if you had something, that had to be done with your heart. I think the other thing is like what Jack was saying, like when he went to introduce Patrick, everyone, all my colleagues at other organizations, they're like, you have a funeral director on your panel? And I'm like, why wouldn't we? That is, like Patrick said, it's the first person you go to. And I know I had a personal situation with my dad. Okay, Mom, not knocking my father. I know he's up there in heaven. But Dad, I love you dearly, but never thought about this. He was all about living life and never thought about the end. And we had many conversations, and he used to always say, your mother knows everything. It's all taken care of. I would go to my mother, Ma, do you know everything? And she's like, no. And I'm like, it's totally
Well,
denial.
she actually said in Italian, "Matusi Paz," which means, "Are you crazy?"
She's
I
not-
want-
so she didn't
But
say it that way.
I will tell you,
you
there's another attorney in this group that I wanted to just share this, which is kind of
Right.
funny, but not. Because all of these conversations are so charged, they're so emotional. And depending on who,
Yeah.
if you're the fortunate person to have the privilege of sitting down and speaking with someone about their life's plans, you have to be prepared with all, to refer to any avenue that benefits them. And I had a situation where a gentleman, a married gentleman with children, decided to put his house that he inherited, he and his sister, from his old aunt, that she passed on. He inherited it. He decided to put it on the market. Now, my job, of course, is to have a conversation with him. We talked about his wife's, role in this process. And he said, no, I'm the only one that is required to sign. I looked at the documents. Everything was on the up and up. He put the house on the market. The day he put the house on the market, his wife packed her bags and left him. So we had to actually, because she said that he did that underhandedly and that she loved his aunt more than she loved her own mother. And so now I was in a position where we had to talk through what happens with this asset now. And I had to refer him to a divorce attorney. So there's a lot of things that happen because now she's contacted a divorce attorney. He was married for 45 years, had no idea what to do next. So we had to sit down about, how do you become informed now in this next phase of your life? So, by the way, they're back together again. So this was only a temporary problem, but things happen so significantly. You don't realize how charged these conversations are and these matters are until you're involved in them. So we are definitely a collective.
Right.
I want to add too with the trusts. I've had many occasions where a family has spent all of their money, or the deceased now's money, all of it spent on their long-term care, and now the family's coming to make funeral arrangements, and no one ever told them that they could have set aside some of the assets prior to it all going to the nursing home. Into
Right.
a
So
funeral
yeah,
trust.
that is true. So
So-
Medicaid does allow you to set aside an account for funeral expenses, and they also allow you to create an irrevocable burial trust, right, with a funeral home in any amount. So,
Yes.
and you can do it for your spouse, and you can do it for your children. So that's a planning technique that we use also, is to set up these funeral trusts for families. And those assets are there for burial. It could be for the individual, their spouse, their children, and we can put $50,000 into these trusts sometimes, depending on the situation.
Patrick, I
Allowing
actually
other
have
family members as well now. You can set up that trust before as a spend down, not only for yourself, for your spouse, for your children. Yeah, no limit.
Patrick, I have a question when you were mentioning about the agent. What happens if something happens to the agent, and who actually is the agent? Is it the funeral parlor?
No, the agent is who the family, who the
Designates?
person designates as an
And
agent.
what if that person changes?
You
then?
can designate a backup agent.
Oh, okay.
There's an alternate.
The same thing happens in wills and everything else. You have
Primary and successor.
Right, your primary and
Right.
successor, right.
yes, primary and successors.
We do have another question again about the irrevocable trust, Kitty Prager. Can you put a clause in the irrevocable trust that says the house remains part of your estate?
You kind of defeat the purpose of the Medicaid planning. I believe I'll let Tanya weigh in on that. But the trust only controls those things that are owned by the trust. So you wouldn't transfer the deed to the trust then. if that was your intent, that you want the house to pass outside of it.
Right. Because if it's in the trust, then it's not in your estate. So you have to figure out what it is you're trying to accomplish.
Right.
When you're thinking about that question, what is it that you want to do, really want to do?
And by the way, when any person on this call or even ourselves want to get advice, the one thing is you should update at least annually, unless something happens in the middle of the year or something, is you always should have a net worth statement. That is basically an inventory of what you own, what you owe, and the A minus B equals C. Because
Right.
if you go to an attorney, they're going to rely on what you give them. They can do a title search for things that are titled, but they're not going to be able to find accounts that you have, bank accounts and all that stuff. And if you want to give a nightmare to your heirs, then not having your stuff together, not knowing where things are, finding the mason jar behind the stove. My wife did that with her aunt. It had $30,000 in it. You laugh at all these stories in New York, all this kind of stuff. It is so important to, if you're the ones who have parents, get to your parents. If you're the parents, don't leave a problem to your kids or whoever you're designated to take care of these things. The little bit of money you're going to have in the scheme of things can save the family not only money, aggravation, frustration, and time. And the people on this call are there to give you all their options. Everyone on this call, as far as I can see and understand their role, is a fiduciary. That means that their job is to act in your best interest. And part of that best interest is to know when to get another expert involved to coordinate this. That is our job. I can't do everything. I understand the majority of all the estate planning things. I don't know everything about Medicare simply because most of my client base has some money, as Tanya pointed out. Everybody will die, so they should be talking about planning ahead for funeral arrangements. And going back to real estate, there's a couple of things I just wanted to point out that maybe didn't come up. When somebody starts to get ill and sick and they want to stay at home, they got to be realistic on whether the house is set up for them to stay there. They can be able to move around the house. There's some houses that are so old or set up in such a way that they can't meet any ADA regulations, let alone anything you want to try to do for yourself. When I built my house and I knew my in-laws were coming, I made all the doorways 4 inches wide for wheelchairs. And guess what? It actually happened. So those things are really, really important.
Tanya?
Just quickly, I just want to make sure that people understand that there's a difference between Medicare and Medicaid. So Medicare
Yes.
is health care for individuals over 65
I meant
or
Medicaid,
if you're disabled. Medicaid is a need-based program. They look at your
Correct.
income and your resources to determine eligibility. So Medicare typically does not pay for long-term care in a nursing home. They will pay for days 1 through 20, 100%, days 21 through 100, there's a copayment. And once you've exhausted the 100 days of Medicare, that's when Medicaid would kick in. Medicaid is a payer of last resort. You have any other assets, any other insurance, that has to, or long-term care insurance, for example, all that has to be exhausted before Medicaid will kick in. I just want to make that.
And
Yeah,
one other
thanks
thing
for
is-
clarifying that, Tanya. I appreciate it. We're actually past the 1 o'clock mark. As you can see, we could probably go on and on. There's just so much information, and that's why St. John's is providing power lunches. It'll be at noon. Luke will, once again, my student associate, Luke Nordstrom, will just show you the next couple of power lunches that are coming up, but we'll have it during the course of the year. So we will get into the nitty-gritty of trusts. We'll get into talking a little more about real estate and other topics that were discussed here today. The trust and estate obviously is a big one because it's impossible to cover everything on this call. But I hope you thought this was very informative. If you have questions coming up along the way, by all means, this is your St. John's family. So we're here to help you through all of this and answer your questions while you're talking to other advisors. So this is our next one, is coming up February 12th. We have a great team that's going to talk about real estate. So if anyone has just like any really quick last minute that maybe we didn't cover? We have a couple more minutes. Anybody? I think, John, you wanted to say a quick minute. Is there something you wanted to say?
The only
No,
thing is,
there's-
maybe John would, what is a qualified charitable?
Travel distribution?
Uh,
Excuse me,
qualified
Dick?
Okay, I'm just going to answer his question. When you are at the point where you are required to take out distributions, required minimum distributions, and there is a rule that at 70 and a half, I don't know how they came up with that age, but it was probably some legislator that says I want to do it because this is my age. At 70 and a half, you're allowed to start giving away money out of your IRAs directly to charities and reduce your required minimum distribution that would otherwise be taxed. So there is a certain limitation on that. For 2025, it's up to $108,000. So if you're trying to give away money or you want to reduce your estate, you can do it up to $108,000 a year right now, currently.
All right, thank you. Just to let everyone know, this was sponsored by the McAllen Society. We're celebrating our 25 years. And if you put your states in order and you happen to include a charity, which is St. John's University, you become a member of this wonderful legacy society. We do great events. It's great networking. It's great socializing if you're retired and you want to come back and make new St. John's friends. It's a great place to be. So I hope you will consider becoming a member of the McAllen Society. But once again, thank you, and I hope we see you on February 12th.